This law, he said, tells same-sex couples in all the world that their otherwise valid marriages are unworthy of federal recognition. This places same-sex couples in an unstable position of being in a second-tier marriage. This differentiation demeans the couple whose moral and sexual choices the Constitution protects, and it humiliates tens of thousands of children now being raised by same-sex couples. This law interferes with the equal dignity of same-sex marriages by treating those persons as if they are living in marriages less respected than others. This federal statute, this law, is in violation of the Fifth Amendment. When the rulings come out like this, in stacks of paper this deep, in small print, and there's a bunch of dissents, and the dissents are long, and the rulings are long, and they all come out all at once, it can take a little time to comb through them to find the best stuff. I mean, yes, to find the bottom line of the ruling, is it thumbs up or thumbs down, but also to find the best quotes. The process of figuring out what the Supreme Court has just done starts with this. It starts with sprinting. The physical printed copies of the ruling are made available inside the court. And sometimes reporters themselves, but often interns working for news agencies, make sure they're wearing their fast shoes, and they grab the physical printed out copy of the ruling and they sprint it out to folks like NBC's Pete Williams, who know exactly what part of the ruling to flip to right away to get the bottom line, to figure out who wrote the argument and who dissented, and to start looking for the best quotes. This may be a digital world, but in Supreme Court world, the first word we all get about what just happened in the Supreme Court happens thanks to interns sprinting with paper that is hot off the non-metaphorical presses. This was the BuzzFeed.com map today showing the route that the interns have to sprint at the Supreme Court to get the ruling from the court building to where the network TV reporters stand outside ready to broadcast the news once they get it from the interns. For today's ruling, though, the sprinting was not just in Washington, D.C. Today, the same ruling was also printed out as soon as it was posted online. It was handed to an intern here in an office, no, wrong clip, there you go, here in an office near the corner of Vesey and Broadway. And then the intern, whose name is Gabe, with the ruling in hand, sprinted out onto the street and ran these 5 blocks up Broadway in Lower Manhattan, and then ran up the steps of the building there into the Federal Immigration Court for New York City and handed over the ruling while it was still hot from the printer. He had taken it off 5 blocks south. And in so doing, by being that fast and making it there in time with the ruling in hand, Gabe, the intern, handed over that ruling, and in so doing, he stopped the man you see on the right side of your screen here from being deported. His name is Stephen. He's legally married to the man you see on the left side of your screen, his husband, Sean. When Stephen ran into a visa snafu of some kind, the fact that he was married to a U.S. citizen should have been enough for him to not have to worry about being deported while he sorted out the visa problem. But until Gabe, the intern, sprinted into that courtroom today in Lower Manhattan with news of what had just happened at the Supreme Court in Washington, that immigration judge in New York was not allowed to consider Stephen to be a married man. His marriage was invisible to the court, and so Stephen was gonna be deported until Gabe, the intern, arrived with this in hand. And Stephen's marriage, with the delivery of this ruling, became legally visible, and his deportation was stopped. The DOMA Project was helping Stephen and Sean fight their case. They've been helping them, and that's the place where Gabe interns. And Sean and Stephen's case is not at all over. It's not all won and settled. But the proceedings to deport Stephen stopped today at 10:30 a.m. Want to see Gabe the intern, who's the hero here? Look, God bless him. There's Gabe. And God bless the sneakers that he wore to work today. There are not that many cases in a lifetime where a court ruling instantly changes the circumstances of thousands of people's lives. That very day, that very morning when it happens, within 30 minutes. But that happened today. There are about 25,000 couples in analogous circumstances to Stephen and Sean, where one member of the couple is an American citizen and the other one isn't. Those couples' prospects and circumstances in terms of immigration changed dramatically today. Their lives changed radically today. For American couples where one spouse is a member of the military, basic questions like whether you can live on base, whether you can have health insurance, whether you can get the child care for your kids that other married couples get on base. Those prospects and circumstances changed dramatically today. In any case where the things that you get because you're married redound to you from the federal government, those material facts of life just changed. And some of it is going to be instant, like stopping Stephen from getting deported today because Gabe the intern was fast enough. Some of it's going to take a while to figure out. So there was some discussion today that the Social Security Administration might have a particularly Byzantine path to figuring out how to treat all married couples the same now in terms of Social Security. But overall, because of what happened in the Supreme Court today, it is a matter of how and not if. The if is settled. It's going to happen. The federal law signed by Bill Clinton that banned the federal government from recognizing the marriages of same-sex couples, that law is dead. It is unconstitutional. And now the federal government, in its many iterations, will recognize those marriages just like everybody else's. It is as clear as day. It's right there on page 26. By treating those persons as if they are living in marriages less respected than others, this federal statute, this law, is in violation of the Fifth Amendment. But here's the rub. Look at the very next line of the ruling. This opinion and its holding are confined to those lawful marriages. Those lawful marriages that already exist. So that means that every same-sex couple who is married or who will be married in the dozen states that allow that now, they just had their lives changed dramatically. You now will have all the rights that straight couples get federally. So that means Social Security and immigration and filing your taxes and veterans benefits and the military and all of that. All federal issues will now redound to you just as they do to every other married couple in the country. That said, if you live in a state that does not allow same-sex marriage, even after these rulings today, you still cannot get married. This ruling does nothing for you. Yet. Today, during MSNBC's coverage of these rulings today, Chad Griffin from the Human Rights Campaign was asked what he plans to do next now that these cases have been won in Washington, the DOMA case and the California Prop 8 case. And Mr. Griffin said he was going to go first to California with the California plaintiffs to celebrate in California, but then tomorrow he was going somewhere else to get back to work.
It also says to that young person in Hope, Arkansas, or still in Altoona, Pennsylvania, that marriage equality is coming to them very soon. This entire team is on our way to California to celebrate tonight, and tomorrow morning I wake up and fly to Salt Lake City, Utah, to a red state.
To Salt Lake City, to Utah. Utah, where same-sex marriage is most assuredly not legal. The reason you go there next, though, is because here's what's going to happen. Some happy couple, looks like Sean and Stephen maybe, right? Some happy couple who's married in New York or married in Iowa is going to get transferred to Utah for work. And that couple with their kids pay their taxes and they own property together and whose lives are totally interwoven thanks to all the normal married boring stuff that interweaves our lives. That couple's going to move to Utah. Maybe they want to move to Utah. Maybe they got to. It's a work transfer, whatever. But then what happens when they get there? What? Utah unmarries them? No, not here. It doesn't apply. You're married nationally, but you're not married in this state? How does that work? That does not work. And then this hypothetical couple arriving in Utah and realizing this ridiculous situation, they will sue. They will say, hey, we're not looking for a fight here, but this does not make sense. Either we're married or we're not. We cannot be legally married and not legally married at the same time. It can't be that the federal government and the state we came from and the state we got married say that we're legally married, but now that we're here, it doesn't count. It doesn't work. So they will sue. And you know what? They will win because of what happened today. It was 10 years ago today. The same justice who wrote today's decision striking down DOMA wrote the opinion in the last huge gay rights case before the court, which was Lawrence v. Texas. That case declared sodomy laws to be unconstitutional. But the conservative justice, Antonin Scalia, was having none of it. His side lost the argument, but Antonin Scalia wrote a dissent in the Lawrence case that day that has become legendary over time just for its sheer level of rage. Aside from the sheer joy, though, of seeing Justice Scalia rip through page after page of bigamy, incest, adultery, fornication, bestiality, deviant sexual intercourse, obscenity, masturbation. Aside from the sheer prurient pleasure of seeing Justice Scalia exclamation point himself through that very angry dissent. That very angry dissent 10 years ago did get one thing really, really right. Right there on page 15 of the angriest dissent of all time, he nailed it. This is from 10 years ago, and Justice Scalia was furious about this. He said, the Texas statute undeniably seeks to further the belief of its citizens that certain forms of sexual behavior are immoral and unacceptable. The Bowers decision held that this was a legitimate state interest, but the court today reaches the opposite conclusion. The Texas statute, it says, furthers no legitimate state interest. If moral disapprobation of homosexual conduct is no legitimate state interest, then what justification could there possibly be for denying the benefits of marriage to homosexual couples? Right. I think I feel differently about that than you do, but right. Justice Scalia raised this point in horror 10 years ago today, on the last big gay rights case that had its majority opinion written by Justice Kennedy. And he was saying, you realize this ruling means gay people are going to be able to get married, right? You realize that? Yes, Justice Scalia, we realize that. And indeed, Justice Kennedy today cited that 10-year-old ruling twice, when he wrote today that the federal government has to recognize all marriages that are recognized in the states, even if some of them have the gay. But on this specific issue of Utah, what happens now in states that do not recognize all marriages? Everybody's been saying all day today that the court is essentially silent on Utah. The court doesn't say anything about states where same-sex marriage isn't legal. It's not really true. Once again, just like he did 10 years ago, Justice Scalia is pounding his chest and raging into the night angrily that his battle against gay rights is over. It's over because of this latest ruling. When that hypothetical couple that moved to Utah sues to try to make even Utah recognize that their marriage that is recognized by the federal government should be recognized by Utah too, when that happens, Justice Scalia says that today's ruling is going to give them everything they need to win that case and make Utah recognize same-sex marriages as well. He said in his dissent today, the view that this court will take about state prohibition of same-sex marriage is indicated beyond mistaking in today's opinion. He quotes all the court's reasoning about why the federal government has to recognize same-sex marriages, and then he says this: how easy it is, indeed how inevitable, to reach the same conclusion with regard to state laws denying same-sex couples marital status. He says it is only a pretense that today's prohibition of laws excluding same-sex marriage is confined to the federal government. He says the other shoe will drop about state laws banning same-sex marriage, quote, later, comma, maybe next term. You think he's right? He was right 10 years ago today. He was right the last time. If today's rulings mean not just that marriage equality will be true again in California, and that 100 million Americans will live in states that afford not just skim milk second-class marriages, but full-class marriages, even if you're gay. If it doesn't mean just that, but it also means beyond even those things. By the way, this also paves the way for all 50 states to recognize marriages equally, fully equally, much to Antonin Scalia's evident horror. Well, then today is an even bigger day than it seemed at first. Chris Perry and Sandy Steyer were two of the named plaintiffs in the California case, in the Prop 8 case that was decided today alongside DOMA. Watch how they put it.
We believe from the very beginning that the importance of this case was to send a message to the children of this country that you are just as good as everybody else, no matter who you love, no matter who your parents love. And today we can go back to California and say to our own children, all 4 of our boys, your family is just as good as everybody else's family. We love you as much as anybody else's parents love their kids, and we're going to be equal.
We thank the justices for letting us get married in California, but that's not enough. It's got to go nationwide, and we can't wait for that day. It's not just about us. It's about kids in the South. It's about kids in Texas, and it's about kids everywhere. And we really, really want to take this fight and take it all the way and get equality for everyone.
Everyone in this entire country. It's about kids in the South. It's about kids in Texas. Not just theoretically in the future. That's what this ruling today was about as well. It is underappreciated today, but this went way further than everybody's giving it credit for.